What is the main objective of criminal law?
Main objective is to regularise behaviours of people in public. Without the criminal law, you could say, well, without the police in general, it's the difference between perhaps an orderly, civilised society and chaos. If there was no judicial system, then there would be no sets of rules to punish people for committing offences. Therefore, people who had committed an offence, that some elements of the governing system would get a lesser sentence than somebody else. The criminal justice system is designed to apportion penalties and punishments to people regardless of race, colour or creed. That's why you see on the outside courts, you'll see a lady justice holding a scales and a sword. And that's designed to show that she's defending the law on behalf of the public at large.
What is the rule against self-incrimination?
The rule against self-incrimination pretty much states that you cannot be forced to give evidence against yourself or to incriminate yourself. And that rule dates back to the 1600s when the Puritan religious sect, which had pretty much started in England, were evicted or kicked out of England. They went to Holland, which at that time was a very liberal country and still is. But they eventually got kicked out of Holland too because they were trying to proselytize to people there, and they went across to America. But when they were in England, they were being tortured and forced to confess to certain things. And because they wouldn't confess voluntarily, they were tortured until they did. And so that rule against self-incrimination originates back in that time, and it's been maintained in countries right around the world ever since.
Who has the burden of proof in a criminal case?
The state, the government, the prosecutor, however you want to put it, they're the ones who have the burden all the time. And it never shifts from them to the defendant. In civil cases, the burden of proving something can sometimes move to the defendant to kind of disprove something. But in criminal cases, it never leaves the prosecution. They have to shoulder it all the way through to the end. And they must prove every element of the case beyond a reasonable doubt. If you have a defense as a defendant, then the state have to disprove your defense. They have to show that couldn't be the case. So sometimes the burden does switch a little bit to the defendant, but rarely. In nearly every criminal case, all the way through, start to finish, it's the state, and they must prove it, as I said, beyond a reasonable doubt, always.
How do judges think?
It's a really good question. I really don't know how they think. I think that if I had to guess, I would say that when you become a judge, you're removed from your previous position as a lawyer. You're no longer a lawyer. You're now a judge. And when you're a member of the judiciary, you're in a kind of an elite club of people. Access to that is restricted. And there's certain norms and behaviours that are expected of you once you're there. Once you're in that position, precedent really takes is a very big thing in their lives, because all of the people that went before them, you have to uphold that tradition of professionalism and to be part of an institution that's respected. So they have to really follow the code of the judiciary that has gone before them, stretching back over 200 or 300 years. And not to do stuff that would maybe bring the judiciary into disrepute.